This is another iRaw podcast. We podcast to make the world a better place for animals.
It's both kind and rational to like knowing animals. You can't deny it's fashionable to like knowing animals.
Hello everyone and welcome to Knowing Animals. Knowing Animals is a podcast in which we speak to animal studies scholars about a piece of their work. I'm Josh Milburn and I do like knowing animals. This episode of Knowing Animals is brought to you by the Animal Publics book series from Sydney University Press. This is a collection of books that covers the entire disciplinary range of animal studies. And that includes animal law, which is the topic we're going to be discussing today. For example, the series published Australian Animal Law, Context and Critique by Elizabeth Ellis in 2022. To learn more about that book and others in the series, check out the Sydney University Press website. And also a quick shout out to Elizabeth Usher, who provided the updated theme tune for Knowing Animals. To learn more about Elizabeth, visit veganthews.com. Now today I'm very pleased to introduce you to Professor Delcianna J. Delci is an Associate Professor of Law and the Director of the Animal Law and Policy Institute at Vermont Law and Graduate School in the United States. Her published work addresses the law around farmed animals, slaughterhouse workers, captive wild animals, animal advocacy, animal testing, and related subjects in animal and administrative law. Today we're going to talk about her 2022 paper, Treating Humans Worse Than Animals, Exposing a False Solitary Confinement Narrative. This appeared in the Cambridge University Press book Carceral Logics, Human Incarceration and Animal Captivity, edited by Laurie Gruen and Justin Marceau. And I'm pleased to say that this book is open access, meaning that you can read and download Delci's chapter and the rest of the book free of charge from anywhere in the world. Welcome to the podcast, Delci.
Thank you so much for having me.
Can you start by telling us what led you to work on this topic?
Yeah, so I intended this chapter sort of as a provocation. I'm very sympathetic to the anti-carceral movement. I have a brother who's incarcerated, but I was troubled by claims that I would see suggesting that we're somehow treating animals better than humans, which is the title of the chapter, and it's taken from a headline of a Democracy Now! Story. And that seemed inaccurate for one thing, but also to be dividing folks who potentially could be really good allies and collaborators. And so when Justin Marceau and Laurie Gruen, who are both people I respect tremendously and who've influenced my thinking, invited me to provide a chapter for this book, I thought that would be a good fit. And I could try to set the record straight while also trying to encourage collaboration.
I was intrigued to hear that the United States is something of a leader when it comes to both the solitary confinement of humans and the solitary confinement of animals.
Yeah, it's quite troubling. We have, as I say in the chapter, the dubious distinction of being a world leader in confining human beings in solitary confinement in prisons and confining non-human primates primarily in laboratories. So we have tens of thousands of primates confined in laboratories. So we were one of the last nations to end experimentation on chimpanzees, but we've continued to test on other primates and of course lots of other animals. And despite laws that are supposed to protect primates, at least from solitary confinement, many thousands of them are still housed alone.
I think it's striking that you mention chimpanzees and other primates because they're some of the only animals who are actually protected, at least in theory, from solitary confinement in federal law. Is that correct?
Yeah, that's right. And so, one of the things there are these articles out there from advocates in the anti-carceral space, folks who are working against human solitary confinement. And, the headline that I drew from is not alone. There are lots of other statements like that, and statements like research is so heavily regulated, you can't keep animals alone, you have to go through all of these levels of review. And that's really a tremendous misunderstanding of what the law says and how the law is implemented. And so we do have a federal law in the United States, the Animal Welfare Act, that is supposed to ensure the humane treatment and care of animals used for experimentation. exhibition, and the wholesale pet trade. But the actual contents of that law are pretty sparse and it's poorly implemented. And so Justin Marceau, one of the editors of the book, actually has an article out suggesting that perhaps the Animal Welfare Act is doing more harm than good, because it puts out this notion that there's laws and protection in place that make it easier to justify what they're doing. So the vast majority of animals, there is no attending to their social requirements, even very deeply social animals. But primates are one of a very small handful of animals who the law does say you are supposed to pay attention to their social needs. But what happens in reality is quite different from what you would think that would require.
So let's disaggregate these. So in theory, what protections exist for these animals?
So there are actually now 4 categories of animals. When I published the chapter, there were 3. There's a new one this year who there's some attention to their social needs in the law, and it's a little bit different for each category. But the categories are non-human primates, marine mammals, dogs, and then the new one is birds. Congress amended the Animal Welfare Act more than 20 years ago to make it clear that birds are supposed to be included. But the U.S. Department of Agriculture, which is tasked with implementing the Animal Welfare Act, has failed to regulate birds for more than 2 decades. And I've been involved in litigation and other efforts challenging that. And finally, as a result of a lawsuit, they did promulgate regulations just earlier this year that require attention to the social needs of birds, of social bird species. And the way that it's handled for birds and primates is quite similar. And so for primates, originally, there was a law that was passed requiring special attention to the unique needs of primates. And that was in the wake of the Silver Springs monkey scandal, where an undercover investigation revealed horrific treatment of primates in a laboratory, including solitary confinement. And so there was legislative action as a result of that. And the lawmaker who wrote the legislation was very clear that he intended this to protect the social needs of primates. And the law then gets implemented through the agency, the U.S. Department of Agriculture, through regulations. And initially, their proposed regulations said, the science shows most primates are highly social species. We are going to require, the default presumption will be social housing. They will be social primate species will be housed with other primates. And they, cited the scientific literature that supported that and got massive backlash from the biomedical industry. And as a result, stepped back what they were proposing and said, okay, we're just going to require that you have a plan that attends to the psychological needs of primates, and social needs are one of those. But your plan is something you keep yourself. You don't have to submit it to us. We might look at it when we come out for an inspection. If your veterinarian says that a primate should be housed by themselves, if your experiment protocol requires that, you can do that. Just put it in your plan. And, the plans wouldn't be available under the Freedom of Information Act. And that's how it ended up. And very shortly thereafter, it was quite clear, including from inspectors themselves, that this was not enforceable, that the interpretation was basically, as long as you had a plan, you were fine. It didn't matter what was in that plan. It didn't matter if you were following what was in that plan. And so as a result, we still, decades later, have thousands and thousands of primates housed alone, mostly for convenience. With dogs, it's a little bit different, but somewhat similar. So the U.S. Department of Agriculture for many years insisted that dogs did not need exercise. They said there's no evidence dogs need exercise, so you can just keep them in cages all day. And finally, Congress stepped in and amended the law to say, no, dogs need exercise. And so the USDA again began this regulatory process. And initially they said, the science is clear that dogs will exercise more if they have companionship, if they're with another dog or if they're interacting with a human. And so we're going to propose exercise and social requirements. Again, they got backlash. They scaled things back. They took out the reference to social requirements in the law and basically went to a plan requirement and said you need to have a plan for the exercise of dogs. They recommended that if the dogs are housed alone, so that wasn't permitted, they have some human interaction. And, it refers to petting, stroking by a human, and that's kind of a remarkable thing to see in the law. But in fact, that is just not enforced in any meaningful way. Again, polling of the inspectors found that it wasn't giving clear enough guidance to the regulated entities or to the agency tasked with enforcing the law. So it's become pretty meaningless. For marine mammals, it's a little different. So the presumption is social confinement of marine mammals who are primarily social in the wild. They are supposed to be with species they would interact with in the wild or conspecifics, preferably. You can have a plan to have an exception to that, and that can be done by the veterinarian who's on the payroll of the person holding the marine mammal. So there's some conflict of interest and delegation concerns there. But on its face, it seems a little bit better. However, the U.S. Department of Agriculture is not really enforcing that standard. So at the time I published the article, there was not a single citation in about a 5-year period for violating that standard. I did do a quick check just to look at recent inspection reports, and there have been a few citations since, mostly for housing incompatible animals together, where animals are injuring each other and not being separated. But there have been 2 for solitary confinement of marine mammals, just citations, not enforcement action. So it's not too meaningful, but it's a baby step. One for a harbor seal who was confined alone at the Rhode Island Zoo, and then one for a number of manatees who were housed alone at the Universidad Interamericana de Puerto Rico. But most notably, the orca Lolita, who's also known as Toki, and Scully, who passed away recently, has been alone for more than 40 years. She was held alone for more than 40 years until she died recently. And she was in the smallest orca tank in the world for more than 50 years. And the USDA did nothing about the fact that she was housed without the company of a single other orca. So I should correct myself. She wasn't alone. She was with Pacific white-sided dolphins, but those are animals she would not interact with in the wild, and they actually injured her. So they would rake her skin, causing significant injuries to her. And yet the USDA did absolutely nothing. And after the article was published, the USDA took a very strange and unprecedented step of saying, Miami Seaquarium, you can't have Lolita on your license to exhibit anymore. You can't exhibit her anymore. And they never before had carved out an individual animal from a license. And the effect of that was to remove her from public view, which was the only oversight that there was, and to remove her from U.S. Department of Agriculture inspections and the need to comply with any requirements. And tragically, she died just as preparations were underway for her to be returned to her home waters in a sea pen and to be able to at least communicate with her pod again. And she knew the dialect of her pod still, and her mother is believed to still be alive. In birds, it's a similar, we don't know how it's going to play out, but it's a plan requirement virtually identical to primates, so I'm not very optimistic about it.
Could you explain what you mean by a citation, just for those who are not familiar with US legal terms?
The way that the Animal Welfare Act works, it's a licensing and inspection regime. So in order to engage in a regulated activity, experimentation, exhibition, breeding for the pet trade, you need to have a license. There's a vocabulary distinction I won't dive into too much. Some have certificates, some have licenses, but you need to be registered with the agency. And then you need to be open to routine inspections during business hours. They're supposed to be unannounced. And those inspections are supposed to assess for compliance with minimal welfare standards. And they truly are minimal, but they include the social requirements that I've been talking about. And so when an inspector goes out, if they see a marine mammal who's housed alone, for example, of a social species, they are supposed to at least see if there's a plan designating a reason why this animal is alone. And if there's a violation of any sort that's documented as a citation or a non-compliant item, it's sometimes called, it's a violation, really, on an inspection report. And those are made publicly available. But that doesn't mean anything. It's not an enforcement action. There would need to be a subsequent enforcement action in order for the violation to really mean anything. And as I've detailed in some of my other scholarship, the primary way that the US Department of Agriculture so-called enforces the Animal Welfare Act is through the use of warnings, which just say, if you keep violating the law, we might do something. And then they most often do not do anything when you keep violating the law. So, and that's why I say, even when there's a citation, it really doesn't mean a whole lot.
Gosh, so you're documenting these very tiny handful of citations, but that's still a long, long way from anything like a criminal charge.
Absolutely. Yeah, it's a long way from anything, even a paltry fine. It's very unlikely that anything will result for it. And therefore, it's unlikely that a profit-minded entity has any motivation to make changes. And indeed, there is evidence, the U.S. Department of Agriculture's Office of Inspector General has found that even when there are fines, they're so small because the agency discounts them, they are treated as a cost of doing business.
I was really intrigued later in the article, you turned to look at the Endangered Species Act, and you showed how that's been used to challenge solitary confinement of some animals. Now, I confess that actually really surprised me, as I'd always associated that with species protection rather than welfare provisions.
Yeah. And so I have another book chapter about captive wildlife under the Endangered Species Act. And that is the impression that most folks have, even law students coming into it, that the Endangered Species Act is about protecting species in the wild and their habitats. But in fact, that statute is broadly written. And so any member of that species, regardless of where they're located, including in captivity, regardless of whether they're born in captivity or not, is protected by the statute. So Lolita, for example, as a member of the critically endangered southern resident killer whale population, was an endangered species. In recent years, there's been litigation, some of which I've been involved in, using the Endangered Species Act to help captive wild animals, mostly to step in where the U.S. Department of Agriculture has failed them under the Animal Welfare Act, because the Endangered Species Act, unlike the Animal Welfare Act, has a citizen suit provision. And so that allows any person who can establish legal standing, which is a big hurdle in the States, but if they can establish that, they can sue to get injunctive relief on behalf of individual animals. And so we've seen it used quite a bit for animals at roadside zoos primarily, and it's been used with success. And so judges have said the take prohibition in the Endangered Species Act, which prohibits taking an animal, which includes harming, harassing, wounding, includes, in some cases, confining a social animal alone in solitary confinement. And so there's a case where a judge ruled that holding lemurs, who are extremely social and live not just in groups of two, but in much larger groups by themselves, violates the Endangered Species Act, is harmful to that individual animal. Similarly, lions, who are extremely social, that's a violation. And the result of that was that those animals were able to be rehomed in reputable sanctuaries where they could have social interactions. The U.S. Department of Justice notably then went on to build on that precedent and to file suit regarding solitary confinement of lemurs, and was successful there. So it's a really great tool, but it's also a limited one because it can only be used for individual animals who happen to belong to a species that has been listed under the Endangered Species Act. That's not the majority of species. And it's also quite costly to bring these lawsuits, and you need to overcome the standing hurdles. So typically it's based on either an organization's harm from the fact of the legal violation or aesthetic harm to an individual who's observed the animals in those conditions. And both of those become much trickier with, for example, animals in laboratories who are behind closed doors and there's very limited information about.
Despite these hurdles with both of these legal implements that you're looking at. Your article actually ends on a surprisingly positive note. You say that government acknowledgements of the harm of solitary confinement, quote, can provide a foundation for a legal structure that meaningfully protects against these harms. So can you see a clear route to that kind of protection from where we are now?
I can actually, and I have to. I have to stay positive in order to keep doing this work. And I think that recognition by courts, by the Department of Justice, that it's harmful to animals to be held alone is quite significant. And we also have all of the science now showing that as well. And that can be a foundation on which to build more laws and policies, and importantly, enforce those laws in a meaningful way. The science now suggests that denying a social being of companionship, of interaction, can actually cause more harm than physical injury. And that's just, it's a hard thing for people to wrap their heads around because you can't see it. It's a mental suffering, but it is still very real. And so these growing acknowledgments from the legislature on the federal level, from courts, from the US Department of Agriculture, even though it subsequently backtracked, from the Department of Justice, are all adding more and more evidence to the fact that this is something real. This is protection that animals should have. There's also a case I talk about in the article that I was involved in under state cruelty laws on behalf of a bear named Ben, who was held by himself at a roadside zoo for many years, where the court order actually made clear that the cruelty law prohibited not just physical harm, physical suffering, but also psychological harm and suffering. That alone would rise to the level of a violation. And that's significant. And I think it's an indication that the law is starting to turn a corner. There's still a lot more work to do, but it gives me hope.
Why do you think claims about human prisoners having fewer protections than animals are so frequent?
I think there are a few reasons. I think part of it is just ignorance. I think there is a widespread perception that we have legal protections for animals, and animals raised on farms, animals raised for food, have no federal oversight in the United States, and they're largely excluded from our state cruelty laws. Most people aren't aware of that. People just kind of assume there must be some oversight happening, and they're surprised when they find that out. Similarly, I think people have this vague sense that there's some regulatory oversight of animal experimentation. And, there's a lot of words in the regulations. It sounds like something meaningful, but they're not aware of the US Department of Agriculture's appalling job of enforcing that law. They're not aware of the fact that the Office of the Inspector General of the USDA has repeatedly condemned the agency for not meaningfully enforcing the law. So I think if you just look at the words of the law, there's some protection, at least for certain species. I also think it's like a nice, easy narrative. If you can say, we're doing this for animals, surely we can do this for human animals, that seems to make a pretty compelling case. The reality is much messier, and messiness is often more challenging to deploy in advocacy efforts. But I think we owe it to ourselves and to others to be really honest and dive into the messiness and the reality of the situation.
I know that a lot of people are very worried about the prospect of any kind of comparison between the abuse of animals and the abuse of humans. Do you worry that placing solitary confinement of humans and solitary confinement of animals side by side, like you do in the chapter, invites comparisons between them?
Yeah, it's a fraught issue. So tomorrow in my Animals in the Law class, our entire class is dedicated to navigating fraught analogies. It's our second class of the semester, and it's something I think it's important to lay out in all of its messiness early on, because it's a recurring theme when you get into this field. And it's particularly challenging in law because law reasons by analogy. That's how it works. And so you're invited to make analogies, but the comparisons aren't simple. And in some ways, it can devalue the experience of either a human group or an animal, a non-human animal group, even though there may be fundamental similarities between the way that the oppression is happening. And so I think already the comparisons have been made. The treating animals worse than humans has invoked the comparison. Also, anti-solitary confinement advocates very frequently rely on science from primate laboratories demonstrating the severe suffering, the distress, the repetitive stereotypic behaviors that are well-recognized signs of suffering in their efforts to show that this is bad for human beings, because humans are also primates. And so I think in many ways the ship has already sailed. And so our job is to attend to the comparison in a very thoughtful way and recognizing the way in which humans and each individual species of non-human animal have certain similarities and certain differences. And nobody is saying that they're exactly the same.
Before we move on to the regular questions, I just wanted to take the opportunity to ask you a bit about the book as a whole. So we've talked a lot about your chapter, but what other kinds of issues are explored in this volume?
Yeah, so it's a great volume, and I definitely recommend that folks take advantage of the open access and take a look at it. And so this volume builds on work that Justin Marceau has been doing for a number of years now, really leading the charge in interrogating the carceral focus within the animal law movement. The emphasis over the years on criminal laws and criminalizing those who cause harm to animals. And so he's got another book that is really the foundation for this, some law review articles. And here, as Lori Gruen and Justin described the book, they say it focuses on the connection between our complicated, contradictory views about crime and punishment and our complicated, contradictory views about non-human animals. They go on to say the book also lies at the intersection of two emerging fields of study, progressive carceralism and what is loosely called anti-carceral veganism. And so there's chapters by a wide range of amazing authors. The main focus of the chapters are interrogating this carceral focus. There are also chapters from those who hold an opposing viewpoint, basically explaining why historically there was that focus. And then mine is, I'm not a criminal lawyer. I've always done civil law, partly because I have concerns about the carceral approach. But I felt that this was a way to add to the discourse that we're trying to bridge between anti-carceral advocates and animal advocates.
Now, Delcy, we ask every guest on Knowing Animals 5 quick questions. Are you ready for your 5 quick questions?
I'm ready.
Can you recall the first piece of pro-animal scholarship you ever read?
So as a teenager, I voraciously devoured everything I could find in my local library about animals. And so I don't rightly recall what was the very first, but Peter Singer's Animal Liberation was certainly one of them and was very influential. A couple others that stand out are Animal Factories by Jim Mason and Peter Singer, as well as Gary Francione's work about animals and the law.
Can you recall the first piece of pro-animal scholarship you ever wrote?
Yeah, so the very first thing I wrote was when I was an undergraduate in college in 1999. I wrote a paper called Linking Victims, Linking Treatment, an examination of the relationship between domestic violence and pet abuse, which my professor described as lengthy but outstanding. And then shortly thereafter, I went on to work doing some independent studies with Donna Haraway on human-animal relationships, so did further work there. And the first piece of pro-animal scholarship I ever published was as a law student. I published a piece about cosmetic testing and animals.
If you had to name one animal studies scholar who's had a big impact on you, who would it be?
This is such a hard question. And I know some people go on to list like a whole bunch of people, but I'm going to try to follow the actual lead of the question. And I'm going to say Donna Haraway because she, we did not agree on a lot of things, but she really mentored me and nurtured my interest in this field at a very early pivotal point in my career and in my life. And that set me on the right direction. She also introduced me to a robust world of scholars in myriad disciplines thinking about human-animal relationships. She encouraged my interest in the topic, and she also gave me my first book acknowledgement.
What do you think is the most important thing that academics can do for animals?
So there's so many things that academics can do for animals. I think there are some academics who are doing really critical work, hashing out the theoretical framework to revolutionize human-animal relationships. I think that's important. Personally, because I'm more pragmatic, that's why I went to law school, I tend to focus my scholarship on policy issues and really to influence legislation, regulation, other legal arenas. But honestly, I think the single most important thing academics can do for animals is to train students to think critically about our relationships with animals, and importantly, to instrumentalize that critical thinking.
If you had the power to change one thing about the human-non-human animal relationship, what would it be?
It would be to end the industrial institutionalized exploitation of non-human animals. There's this great tension right now where there's increased public awareness and concern for animals, but there's also increased harm and exploitation to them. And I think the reason for that is the increasing routinized cruelty that's happening behind closed doors for food, for experimentation, for clothing, the pet trade, etc. And I think if we could end that, that would put such a massive dent in the harm we're inflicting every day on animals.
What are you working on next?
So I'm working on way too many things. I am juggling 5 scholarship projects right now. One of them is about what I'm calling canned photography, which is the use of captive wildlife in really horrible conditions for photographs that appear to be taken in the wild. And these are stock photos that are pretty widely distributed. You'll see them on calendars, in magazines, and even in fundraising appeals and blogs from animal protection organizations. And so this project is aimed at really exposing this issue and trying to address and mitigate it. The thing I'm most focused on at the moment is launching and nurturing our various degree programs at the Animal Law Policy Institute at Vermont Law Graduate School. So in very short period of time, we've launched 3 degree programs focused on animals, all of which are available residentially or online. We've got a Master's of Animal Protection Policy. Our students just started the first class yesterday. We've got JD, Juris Doctor Law degree, and we've got an LLM in animal law, so an advanced law degree to focus entirely on animals. And so that's my baby right now.
How can people find out more about your work?
So if they go to vermontlaw.edu/animal law, they can link to my faculty profile with information about my scholarship, but also information about our other amazing animal law and policy faculty, as well as our degree programs, our events, and other things. So I would recommend that as a first stop. I also am on Twitter, LinkedIn, X, hate saying that, and Instagram.
Well, thanks so much, Delcy, for joining us for this podcast.
Thank you so much for having me.
And thank you, listeners, for joining us for Knowing Animals, the podcast where we talk to animal studies scholars about their work. You can follow us on X at knowing_animals or on Facebook at Knowing Animals. You can follow me on me on X at Josh L. Milburn or on Instagram at A Vegan Philosopher. Please do spread the word about Knowing Animals. And if you're teaching, please consider including it in your reading lists. I'm Josh Milburn, and I do like knowing animals.
For more great iRaw podcasts, visit irawpod.com. That's IROARPOD.com.